Hello everyone, and welcome to this workshop about advocacy. My name is Billy. I'm a senior lecturer at Swansea University, and I'm a part-time barrister at 9 Park Place Chambers in Cardiff, still appearing in court. That makes me ideally suited to teaching students at Swansea University about legal topics, and in particular about advocacy and professional practice. And what I wanted us to look at today was advocacy in court, standing up in court and making arguments, making submissions or speeches, as some people would call them. So what I'd like to do in this session is introduce you to advocacy, explain what it is, to talk about some good, the key features of good advocacy, and then to talk you through an advocacy-based task regarding a legal problem, and you can give it a go if you wish. This whole process should help you understand about advocacy and how and why we learn about advocacy in a law degree. Finally, before we begin, I'm making this video during coronavirus restrictions, and so the software I have to film is limited. It's just my laptop. The location is my spare room, and the format isn't ideal. So it could be better, but it will serve its purpose to provide you an introduction to advocacy and learning about this exciting topic. Let's start with thinking about what is advocacy. People in different parts of society may think of advocacy as being different things, but what do we mean in a legal context? Well, what we're talking about, you've probably already seen on many occasions. Maybe you've seen it on television or in film. Maybe you've been fortunate enough to have work experience in court following barristers, solicitors, for example. But we're really thinking about two things when we think about advocacy. On the one hand, you could be talking about making arguments in court, speeches, submissions, we would call them. On the other hand, you could be talking about questioning of witnesses, examination in chief or re-examination when you question your own witness, or cross-examination when you question a witness of the other side, of another party. For this example, this introduction, we're going to focus on speeches, submissions, arguments that you make in court. And it probably helps you to know, if you don't already, you may do, that there are many different types of courts that an advocate could appear in, such as criminal courts, family courts, immigration tribunals, employment tribunals, civil courts. But for today's lesson, we're going to think about criminal courts. The reason for that is that probably most of you are most familiar with that type of court from what you see on the screen and what you read in the press. There are two different types of criminal court at first instance that determine trials: magistrates' courts and crown courts, in both criminal courts. It's simplifying matters somewhat, but I want you to think of those as being magistrates' courts, minor criminal offences are dealt with there, crown courts, more serious criminal offences. What do I mean by that? Well, magistrates' courts, you'd have things like driving without due care and attention, drunk and disorderly, minor offences like common assault, those sorts of things. Crown courts, we're thinking about more serious offences, rape, murder, serious assault. And one of the main differences between these two, apart from that, obviously the different types of cases that they deal with, the most obvious difference. In a crown court, as an advocate, you're going to wear a wig and gown. In a magistrate's court, you won't wear a wig and gown. For the examples that I'm going to show you, you'll see me wearing a wig and gown. It isn't mine. Mine is in the office, which I can't get into, so I had to borrow one. So I don't have all of the garb that you would need, that I would wear, but I have some of it, just to give you a flavour. So if we're thinking about criminal law, we're thinking about criminal courts, what are the arguments that you might be making, the submissions that you might be making? They might be legal submissions. How should the court interpret a particular section? Or how does this section of law apply to these facts? They may well be factual submissions. Has the person committed the crime or not? If you're for the prosecution, you'll be arguing that it's proved. If you're for the defense, you'll be arguing that there is doubt. But there's a golden thread that runs through all of these submissions in crime or any other area of law, and that's that you're trying to persuade. Whether you're trying to persuade a judge to see things in the way that you're presenting them, or you're trying to persuade a jury to view things in the way that you're presenting them, or not to view them as the other party is presenting them. But a central aim to these arguments is to persuade. So persuasion is the aim of the game. And if you're toying with the idea of becoming a lawyer, you think it's possibly something that you want to do, or definitely something that you want to do, you can see why learning advocacy is going to be key to doing well in that profession. If you're not sure about what you want to do, maybe you're thinking being a lawyer it's possible, but maybe not. Graduate scheme, politics, business. I'd ask you to think about what graduate job that you could go into would not require you to be able to stand up in front of a group of people or make an argument across a table with confidence and try and persuade them of what you want, what you've done, or against what somebody else wants or has done or wants to do. Learning advocacy is undoubtedly going to be relevant to any job that you're looking to do following your law degree. So that brings us to thinking about what the key features of good advocacy are. And I'm going to outline a few of them to you. We don't have time to look at all of them. Good submissions are multifaceted, but we will touch on some of them. So let's think about those features of good advocacy. We'll run through some of them and then we'll look at them in detail. Preparation, eye contact, the pace that you use, and the manner and demeanor that you present your submission in. Let's think about preparation first. You have to know the law. If you're doing a legal submission, it's key to what you're doing. You have to know the facts. Obviously, you're being paid money to make these submissions, and you need to come across as though you know what you're talking about, you know what the case is about. But you also need to know where you're going. What do I mean by that? Well, I mean that you have to follow a structure that makes sense, that flows, and that you're not jumping around to different parts of this case. But what I don't want you to be trying to do when you start out as an advocate is learning things verbatim, off by heart. And there's two reasons for that. The first is that it kills all of your engagement that you have. You sound robotic, you sound like you're reciting something. But the second reason is, and you see it time and again when people start, if you learn a script and then you go wrong or you miss something, it then starts to all fall apart. So you're far better to just learn where you're broadly going and the essence of what you want to get across, the points that you want to get across, rather than the exact words that you want to say. Let's think about eye contact. Use plenty of eye contact. Why? Because it's engaging, because we do it in our natural everyday life, and it shouldn't be any different when you're doing a legal submission. Think about the conversations that you have with friends or family. You don't spend your whole time here looking down at the floor. Why do you not do that? Because human interaction is up here, so it's good communication skills. And we have to avoid just reading our notes. It's fine to use notes as an aid memoir, but what isn't okay is when somebody spends their entire submission reading from the notes that they've made. It lacks engagement and it lacks persuasion. What about pace? Have a measured pace. What do we mean by that? It needs to be slow enough that somebody can follow everything that you're saying, they can take it in and they can understand it. It might also need to be slow enough so that a note can be made, whether that's written or typed in this day and age. But the important thing is that you need to think about the audience that you're addressing. So don't be too fast. The reason why people are fast is normally because they're nervous and they allow their nerves to take control and they just want to get through it as soon as possible. You really have to train yourself to speak at a pace that's probably slower than the pace that you would normally otherwise speak at, especially if you're someone who speaks quickly. What about your manner and your demeanor? Well, you obviously need to be professional. You need to come across as though you're confident, and that can take practice. But you also need to avoid distracting mannerisms. And distracting mannerisms can come in a number of forms, but there's really two broad categories. One is what we do with our body, and one is what we do with our voice. Let's think about fillers. That's what we do with our voice. We all have little ums, ahs in our speech. It happens naturally. And you're never going to want to take away all of those, and you might not be able to take away every single and ah. But when you listen to yourself, and maybe a good idea would be to speak into some kind of phone or iPad, record yourself and then play it back. How many ums and ahs do you use? Are there so many that they become a distraction? And that's what we want to avoid, things that are distracting. People often also fall into the habit of using a particular word. Around here in South Wales, lots of people use the word like. Like they just say things like happen to be like what's on the top of their mind, but like, it doesn't like really mean like anything. The word like in what I've just said is completely irrelevant. It's meaningless and it takes away from what you actually want to say. So be careful, tune in to your own speech. Are you using fillers like that? And remove them, try and remove them to the best of your ability if you are. There's also unwanted body movement. We don't want people to be stood there like a statue or on some kind of army parade. But we don't want something that becomes distracting. And you will have your own habits and little idiosyncrasies. I use my hands quite often in an expressive way when I'm talking, but if I was doing advocacy, I would have to keep control of that urge and really do my best to not use my hands in a way that becomes distracting. Some people in court, when they start off as an advocate, they rock back and forth or side to side, and that can be off-putting as well. And we don't want anything to detract from the lovely words and the lovely manner that you are using. So I'm going to show you two examples in a moment. And when you watch those examples, I want you to think about the things that we have there in front of us on the screen. Is this person well prepared? Do they use eye contact? What is their pace like? Is it measured? Is it too fast? How about their manner? Are they doing anything that is distracting? Do they seem confident? Do they seem in control of themselves and the submission? I'll play you an example with some poor examples, and then I'll play you an example with some good features as well. Let's look at this bad example.
Please call. I'm Billy Seagrim. I'm here on behalf of the prosecution. My learned friend, sorry, what's your name? Johnson appears on behalf of the defendant, Ms. Davis. He's convicted of one offence for assault, occasion, active bodily harm. Now, I wonder if I could have that. Let's begin with the facts.
So, what did you think of that? Consider the features that we talked about and compare what you've just seen to those features. Reflect on this performance. I'm going to play the performance again, and I'm going to stop it as we go through to talk and pull out some of those features, and hopefully you would have already pulled out some.
Please call. I'm William Seagrim. I'm here on behalf of the prosecution. My learned friend.
If we pause it there, You can see that my eyesight is entirely down, buried in my notes. Imagine the judge off in the distance. I haven't really looked at them. My eye contact is therefore very poor. I'm lacking in engagement, and I'm spending the whole time really reading. But what do you think about the pace? I would tell you that the pace is far too fast for somebody to be taking in and absorbing what I'm saying. So immediately we see those two things as problems that can be improved.
Sorry, what's your name? Johnson appears on behalf of the defendant.
Preparation. You need to know who your opponent is, who the defendant is, who are the parties and who are they represented by. It's poor preparation not to have that at the tip of your tongue when you're the person who is standing up first and introducing the parties.
Defendant, Ms. Davis, he's convicted of one offence, assault, occasion, actual bodily harm. Now, I wonder if I could have that.
We've got a continuation of the previous problems that we identified, but we've also got quite a lot of movement, seem to be moving back and forth, which for me at least is distracting. So there's a number of things that you can see from that video that can be improved on. And if I was learning advocacy, I would be looking at this and I'd be thinking, right, let's do it again, but let's try and slow my pace down. And I would do it again, and I'd record myself, and I'd look at it, and I think, right, let's have less movement. I'd do it again. But I wouldn't be looking at verbatim the exact same words. I would be thinking about what I'm trying to get across. Okay. Let me show you a better example.
May it please the court. I'm Billy Seagrim. I appear on behalf of the prosecution. My learned friend, Ms. Johnson, appears on behalf of the defendant. That's Mr. Davis, seated behind my learned friend. He has been convicted of one offence of assault, occasion, actual bodily harm. And as Your Honour knows, the matter is listed for sentence. If I may, I'd like to address the facts and then the defendant's antecedent record.
Let's look at that again, and let's think why this is better than the previous occasion.
May it please the court. I'm William Seagrim. I appear on behalf of the prosecution. My learned friend.
So, my head isn't buried in my notes. I'm looking up, holding eye contact, and my pace is far more measured, far more appropriate. The court is going to be able to hear and follow, understand everything that I'm saying.
Johnson appears on behalf of the defendant. That's Mr. Davis, seated behind my learned friend.
I've remembered the name of my opponent, and I seem as though I'm well prepared for this particular hearing, which will hopefully give the court confidence in what I'm saying.
He has been convicted of one offence of assault, occasion, actual bodily harm.
There's less movement, so it's less distracting. Maybe some people would say there's still too much movement, and if I was going to do this again, I might try and do it again with less movement next time I was going to be doing a submission like this. But you can see the features that we looked at. This second example, I'm not saying it's a perfect example, but it's a much better example of advocacy. So we've looked at what advocacy is, what those features of good advocacy are, and I've given you some examples to help you maybe see what that looks like in real life, bad and good. What I wanted to do now was think about an advocacy problem, to give you a problem to consider that you could give it a go if you so wished. And I'll show you a video of me doing this at the very end too. So let's have a look at this problem. So let me open up the first brief that you're going to receive, a brief before you've even gone to university. Well done. So this is the case that we're going to look at. A fictitious case, tiny made up. Crown against Johnson. Let's think about the facts. So the defendant is somebody called Jeremy Johnson, Mr. Johnson. It's a criminal case in the Crown Court. You're going to be appearing before a circuit judge, so you call them Your Honour. Whether they're male or female, they would be Your Honour. It would be different if you were in a magistrate's court. You would call the magistrate in the middle of the three, because they sit as a three, or a district judge, ma'am if they're a female, and sir if they're male. The scenario that we're going to give you, it's listed for sentence. So somebody has been convicted either after a guilty plea or a trial where they've been found guilty, and they now need to be sentenced for what they've done. And you're going to appear for the prosecution. So the aim of what you're going to do is to outline the case, to say what has happened so that the judge can then go on and sentence this individual. After you have spoken, although we won't see it, I want you to imagine that a lawyer on behalf of the defendant will mitigate on their behalf and try and get them the least possible sentence commensurate with their crime. What's the offence that this person has committed? Well, they've committed an offence of assault, occasion actual bodily harm. And the section of law that's in breach of is section 47 of the Offences Against the Person Act 1861. So it's an assault. You can probably imagine what that is. Actual bodily harm is some kind of harm that is more than minor, more than trifling, but it isn't serious. So we're not talking about somebody with a fractured skull, and we're not talking about somebody who has no injuries at all. Somewhere in between. What about the defendant? Well, they're 35. I've given you their occupation, some of the things that they like doing in their life. They've got 5 previous convictions, 4 for driving matters, and 1 previous assault, a common assault, the most minor of assaults that somebody can commit, but when this person was 18. And I want you to think about the scale of assaults if you don't already know. At the bottom, you have common assault and battery, no injuries at all. Maybe in some instances, not even a touching of another person, but making them think that they were going to be immediately assaulted. And then that goes through to the offence that we've got here, assault occasion actual bodily harm, so some injury, but not serious. And then you have grievous bodily harm or wounding, which is the next up the scale, and we get finally to attempted murder. What are the facts? What's happened? So I want you to pick a date 2 weeks ago, and I want you to imagine that that was the date that the defendant was convicted of assault. And the assault happened 3 months ago, and I want you to pick a local pub to where you are to imagine that that was the scene of the assault. Who was he assaulted? He's assaulted his ex-girlfriend's new partner. I want you to imagine that he was drunk, that it was an unprovoked attack, and the injury that he caused is two large black eyes. The victim, Mr. Kanu, some people would call the complainant in court, some people would call them the victim, had to go to hospital for treatment, no fractures, and the next day when the defendant was interviewed, I want you to imagine that he admitted everything, he apologized, he was remorseful, he said it was because he was drunk. The actual assault, I want you to think that it's multiple punches to the face that caused the victim to lose consciousness. He pleaded guilty at his first opportunity, and there's been what we call a pre-sentence report by the probation service. Now, the probation service are the people who interview accused, defendants, people who are convicted, and they write a report for the court that recommends whether they can do unpaid work or not, whether they're dangerous individuals or not, what the risk is of reoffending. So often in cases, not in very minor cases, but for cases like this, there would be a pre-sentence report that would happen after there's a conviction. Sometimes it can happen the same day, often it takes a little bit of time. It depends on the offence and on the offender. But I want you to think in this case, there's been a pre-sentence report. And there is a Sentencing Guideline Council guideline for assault. Now, the Sentencing Guideline Council is a body that creates guidance that judges follow. Someone once told me they're not tramlines, they're guidelines. So they don't set out exactly what the sentence has to be, but they give a sort of a range based on the facts of the case to say you could give somebody between this, and the starting point should be this. And then the judge uses that as a guide for he or she to come up with the sentence that's appropriate in this particular case, bearing in mind the particular facts and the defendant's particular circumstances. They obviously take into account things like what's going on in that person's life, their personal mitigation, and when there was the guilty plea, if there was one, and what previous convictions the person has. So they're the facts. You can go back to that, pause it, and think about those facts if you need to. But what I wanted to do was talk to you about how you prepare this opening from the point of view of a prosecution advocate. So I will talk you through the structure of what I would be looking to do. I'll give you some examples of what I may well say, and there's some notes on there as well for you to look at. So if you wanted to give this a go, what I would encourage you to do is to look at the next page and adapt it and think about how you would therefore make your submission. Use it as an overarching structure to follow. But remember what I said, never thinking about verbatim, exactly word for word, learning of what you're going to say. Use it as a structure. So how do we prepare an opening? A lot of words on the page. Let's take it row by row. If you look at the left-hand column of this screen, as you look at it, going down the page, you'll see the structure that I would want you to follow. So the first thing you're going to need to do, let's start at the top, is introduce yourself. And I've given you the example of the sorts of things that you would say. May it please the court, I'm William Seagrim and I appear on behalf of the prosecution. This is me and this is the party that I appear for. May it please the court is a bit of an odd phrase, but it's the time-honoured traditional way to open your submission when you start addressing a court. It can be used in a magistrate's court, the Crown Court, the Court of Appeal, the highest court in the land. May it please the court. There are variations to that. If you're in front of a circuit judge, you can say, may it please your honour. If you're in front of a higher level judge, may it please your lordship, your ladyship. But that's the sort of typical way of starting. Looking on that column, the next thing you need to do, introduce your opponent and the defendant. My learned friend, Mr. Davis, appears on behalf of the defendant, Mr. Jones, for example. Why do we call them my learned friend? Again, it's tradition. It's what we say. You'll note that I said Mr. Jones, Mr. Davis. We never use just the first name, the given name. It's far too informal. So you wouldn't say my learned friend Peter appears on behalf of the defendant, Abigail, for example. You have to use those family names. The next thing you do is explain to the judge what the hearing is about. So the matter is listed for sentence, following the defendant's guilty plea, for example. When we refer to the defendant, again, we're using the sort of family name, not the first name terms as a court. Then we outline the offence at some stage of what this person was convicted for. The defendant pleaded guilty to one offence of assault occasioning actual bodily harm. You'll note there that I didn't say, contrary to section 47 of the Offences Against the Person Act 1861. Some people might, some people wouldn't. You could do either. But what I would tell you is that if you're in front of a senior judge who has experienced and dealt with lots of these types of cases, which any circuit judge in a Crown Court would have, because it's a pretty common case, you wouldn't need to say section 47 of the Offences Against the Person Act. They'll know that. But you might change your approach if you're in front of a less experienced judge or maybe a part-time judge. Then you're going to outline the facts. You might have a nice little sentence to bridge into that, such as turn into the facts of the offence on the 3rd of January, etc., etc. Or you might say something like, if I may, outline the facts and then I'll address the antecedent record, or something like that. But then you would, when you outline the facts, stick only to what is relevant. A good sort of rule of thumb for you, if you're prosecuting in this scenario, would be to talk about the offence itself, the arrest and the interview. And that's all for the facts, nothing more. Sorry. It's always a good idea when you're outlining the facts to include obvious things that are aggravating and mitigating, because the judge at the end of the day needs to sentence this person, and when they sentence them, they're going to be looking for what are the things that make this more serious or less serious. But one of the things that I will tell you is that as a prosecutor in England and Wales, you're not aiming for this person to have a particular sentence. So you're not trying to persuade the judge that they should give this person 10 years or 5 years, or as in some other jurisdictions, the prosecution might aim for the death penalty. We don't have the death penalty, but we also don't aim for particular sentences. As a prosecutor, you're impartial. You're just presenting the facts so that the judge can then sentence this person. Obviously, the defendant has the opportunity to mitigate or lawyer on their behalf. You need to talk about whether this person has previous convictions. As very often you have to hand up a copy of the previous convictions as a prosecutor. So you might say something like, I wonder whether Your Honour has a copy of the previous convictions. If they haven't, you would then hand one up. And you want to just draw the court's attention to things that may be relevant. Now that will change depending on the person's list of previous convictions and what they've been convicted for. Finally, you want to make sure that the court has a copy of the pre-sentence report. So you would say something like, I wonder whether Your Honour has seen a copy of the pre-sentence report by Mr. Jones, and whether you outline any sentencing guideline, counsel guideline, will depend on the offence and the judge that you're in front of. If you're in front of an experienced tribunal, an experienced judge, you're not going to need to talk about the sentencing guideline, counsel guideline. They're going to be familiar with it already. If you're in front of a new judge, a part-time judge, then you may need to draw their attention to it. If the offence that you're doing is very common, you wouldn't need to be addressing them about there being a sentencing guideline, counsel guideline for this offence. However, if it's an unusual offence with a rarely used guideline, or if it's a new guideline that's come into force, then you may well need to draw the court's attention to it. So your approach to whether you talk about a guideline, counsel guideline, with the judge is going to depending on the particular case. So that's the structure of how we can do it, with some examples of what you could say. I'll tell you that that's not the way you have to do it. There are other ways to do it. This is just an example for you to follow, to give you some confidence with how you would do it. What I would encourage you to do now is to give it a go. Pause the recording. You can go back to the facts if you need to. You can go back to those features, or you could focus on this page and think about how you're going to do it. But then I'd like you to do it. My advice would be to record yourself doing it so that you can then watch that performance back and critique it, reflect on it, what can be improved in your performance. Think about those features that we were talking about: preparation, pace, manner, eye contact, how engaging are you? You could do it in front of somebody else for them to give you their feedback, and then you reflect on that feedback and think, what was good about that? Were they right? What did they spot that you didn't realize? Things like movement, like fillers. You could forewarn them to look for particular things and say to them, look, have a habit of saying can you note down the numbers of times that I say and whether you think it's a problem? And what I'm going to show you in a minute is a video of me doing this submission, this opening for a sentencing hearing. And you could then watch me doing it and compare your performance to mine and think, were there things that I did that you liked, that you'd want to steal? Has my performance highlighted for you things in your performance that you would want to avoid? So you could pause it now and do your performance, and I'm going to, the next thing will be me playing my performance.
May it please the court. I'm Billy Seagrim. I appear on behalf of the prosecution. My learned friend, Ms. Johnson, appears on behalf of the defendant. It's Mr. Davis, seated behind her. As Your Honour knows, the matter is listed for sentencing of Mr. Davis for one offence of assault occasion actual bodily harm from the 3rd of January of this year. I wondered if I could outline the facts and then address the antecedent record. On the 3rd of January this year, Mr. Davis was in the Prince of Wales public house in Cardiff city centre drinking with friends. On his own admission, he drank around 10 pints of lager and was highly intoxicated. That's when he saw his ex-girlfriend and her new partner, Mr. Khan, the victim of this offence. In an unprovoked and aggressive manner, he attacked Mr. Khan, punching him multiple times to the face. Mr. Khan was knocked unconscious and was later taken to hospital for treatment. Fortunately, he had no broken bones, but he did have two quite bad black eyes, and I think that Your Honour has a copy of a photograph in the file that shows those black eyes. The defendant was arrested that evening, and after sobering up the following morning, he was interviewed. During his interview, he made full admissions to his crime. He expressed remorse for what he had done and sought to blame alcohol as the cause. The matter was listed before the courts, and the defendant pleaded guilty at the first opportunity. We've been adjourned till today. I wonder whether Your Honour has a copy of the antecedent record. I wonder if I could hand one up there. As Your Honour can see, the defendant has 5 previous convictions for 5 offences. The only one that appears to be relevant is one previous conviction for common assault, albeit that was when he was 18. He is now 35. I hope that Your Honour has seen a copy of the pre-sentence report by Mr. James, dated yesterday's date. I also am aware, obviously, that there is a Sentencing Guideline Council for this offence. I know that Your Honour is well aware of that guideline, and unless Your Honour wishes me to, I won't address that. Unless I can assist further. Thank you.
So, just one note, the very final sentence that I said, unless I can assist any further, that, like our sentence to start, may it please the court, unless I can assist further, is a time-honoured way of signing off your submissions. It almost sounds like an incomplete sentence, doesn't it? Unless I can assist further. Some people would say, unless I can assist further, those are my submissions, but when I learnt advocacy, I was told this is the way to do it, and so I share it with you. Hopefully that has given you an introduction to advocacy, some of the good features, and that it's also told you how we teach students to get better with advocacy and how you could get better with advocacy with some of those tips. I hope you found that helpful. See you again. Bye.